The federal courthouse in Washington, D.C., that has conducted peaceful proceedings for over 2 centuries, just witnessed something unprecedented. Not because a case was dismissed, not because evidence was thrown out. Judge Caldwell said it himself. If these lawyers do not comply with this court's orders, I will have no choice but to hold them in custody. I'm Elizabeth Carter, and this is the story that's unfolding in real time across federal courts nationwide. Before we go any further, I need you to do something right now. Hit that subscribe button, click the notification bell. Leave a comment below telling me if you've ever seen a federal judge threaten to jail government lawyers before. Share this video with everyone you know. This is the only official channel bringing you this investigation as it develops. What I'm about to show you is happening right now, and it represents a constitutional crisis unlike anything we've seen in modern American history. Here's what happened inside that courtroom. Judge Sarah Caldwell, appointed 15 years ago with bipartisan support, watched as Trump administration lawyers openly defied her direct orders for the third consecutive hearing. The court reporter captured every word. When government attorney Michael Thompson claimed his office needed more time to review compliance requirements, Judge Caldwell responded, "The time for review ended 2 weeks ago when I issued my preliminary injunction. This court will not be ignored." Thompson shifted in his chair. "Your Honor, we are operating under guidance from the Department of Justice that may conflict with this court's interpretation." Judge Caldwell leaned forward. "Mr. Thompson, your guidance comes from this court, not from any other authority, while you stand in my courtroom." The marshals stepped closer to the counsel table. That moment captures something unprecedented in American jurisprudence. Federal judges threatening to jail federal lawyers represents a complete breakdown of the normal relationship between the executive and judicial branches. This isn't about partisan politics. This is about the fundamental structure of American government. And this is where it becomes undeniable. Judge Caldwell is not alone. In the past 6 months, federal judges in New York, California, Texas, and Florida have issued similar warnings to government attorneys. District Judge Martinez in Los Angeles. Continued non-compliance will result in contempt proceedings. District Judge Robinson in Miami. This court's patience has been exhausted. The pattern is clear and it's spreading. Court clerk Jennifer Walsh, who has worked federal courts for 18 years, told reporters, "I have never seen judges speak to government lawyers this way. Never. The tension in these courtrooms is unlike anything in my experience." Let that sink in. Career court employees are witnessing the breakdown of institutional norms that have held for generations. Here's what nobody is saying out loud. When federal judges threaten to jail federal lawyers, they're revealing that normal enforcement mechanisms are failing. The system depends on voluntary compliance. When that breaks down, judges have only one tool left, the contempt power. And that tool has never been tested against a coordinated pattern of executive branch defiance. But wait, there's something they're not telling you. Even if judges hold these lawyers in contempt, who enforces the order? The U.S. Marshals Service. Who controls the marshals? The executive branch. The same executive branch whose lawyers are being held in contempt. This creates a constitutional crisis that legal experts say has no clear precedent in American history. Constitutional law professor David Chen told the Washington Post, "We are entering uncharted territory. The separation of powers assumes good faith compliance with judicial orders. When that assumption breaks down, the system has few remedies." Translation: the Constitution assumes everyone will play by the rules. When they don't, our founding document doesn't provide a clear roadmap, and it gets worse. To understand how we reach this constitutional breaking point, you need to know how the system is supposed to work. For over 200 years, federal judges have relied on one simple principle. When they issue an order, it gets followed. Not because of force, but because of respect for judicial authority. The U.S. Marshals Service exists specifically to enforce court orders. Title 28 of the U.S. Code states their mission clearly: to provide security and to obey, execute, and enforce all orders of United States District Courts. Here's the case that broke Judge Caldwell. 3 months ago, her court issued a temporary restraining order blocking the implementation of Executive Order 14823, which froze federal grant funding to sanctuary cities. The order was clear: all affected funds must be released within 72 hours pending full judicial review. Simple, straightforward, legally binding. What happened next reveals the systematic nature of this crisis. First domino. The Department of Justice filed a notice stating they were reviewing the order for compliance parameters. Second domino. 72 hours passed with no fund releases. Third domino. A follow-up hearing where government lawyers claimed the order was ambiguous and required further interpretation. Translation: they ignored a federal judge and then claimed they didn't understand plain English. Judge Caldwell found their arguments without merit. Her written order used these exact words. The plain language of this court's order requires immediate cessation of fund freezing and the release of all affected monies. There is no ambiguity. There is no room for interpretation. There is only compliance or contempt. But Judge Caldwell is not operating in isolation. Let me show you the pattern that makes this a national crisis. In the past 6 months, federal courts have issued over 40 restraining orders and preliminary injunctions against various executive actions. According to legal database analysis, 31 of those orders experienced significant compliance delays. 14 involved outright defiance requiring additional court proceedings. District Judge Patricia Martinez in Los Angeles faced identical defiance over immigration detention limits. Her court reporter documented this exchange. The government claims they need guidance from Washington before complying with this court's detention limits. I am providing that guidance right now. This court's order is supreme within this jurisdiction. District Judge Robert Chen in New York confronted the same pattern over environmental regulation enforcement. His written order stated, "This court will not tolerate continued delays masked as procedural compliance reviews. The executive branch does not get to grade its own homework when it comes to following judicial orders." Here's what makes this unprecedented in American legal history. Sporadic non-compliance happens. Individual cases of confusion or delay occur. What we're witnessing is coordinated, systematic resistance across multiple jurisdictions involving different legal issues, but the same underlying defiance of judicial authority. Legal historian Dr. Sarah Williams, who has studied executive-judicial relations for 30 years, told the Legal Times, "I have never seen anything approaching this level of systematic non-compliance with federal court orders. Even during the most contentious periods of American history, there was an underlying assumption that court orders would be followed. That assumption is now in question." Think about that. The basic premise that makes our legal system function is voluntary compliance with judicial decisions. When that breaks down, judges have limited options. Contempt proceedings become their only tool. But contempt without enforcement is just angry words from a bench. And here's where the human cost begins to emerge. Maria Santos, an immigration attorney in Phoenix, represents families affected by the detention order delays. She told reporters these are real people waiting in limbo while lawyers argue about compliance procedures. A 6-year-old girl asked me when her father was coming home. I had to tell her that depends on whether the government decides to follow the judge's order. Let that sink in. Maria's clients represent just a fraction of the people caught in this constitutional crisis. Federal contractor James Patterson from Denver has been waiting 8 months for payment on a highway project because funds remain frozen despite court orders requiring their release. Small business owner Lisa Chen in Seattle cannot access federal emergency loans because the disbursement agency claims they're still reviewing judicial compliance requirements. And these individual stories multiply across every case where court orders are being ignored or delayed. Think about that for a moment. When the enforcement mechanism of our legal system breaks down, real people pay the price while lawyers engage in constitutional standoffs. But wait, there's something they're not telling you about why this enforcement mechanism is failing. The marshals who are supposed to enforce Judge Caldwell's contempt order don't work for Judge Caldwell. They work for the executive branch. The same executive branch whose lawyers she's threatening to jail. Now let me take you inside that courtroom where everything changed. The complete transcript reveals just how impossible the situation has become for government lawyers caught between two masters: federal judges demanding compliance and executive branch superiors demanding resistance. Sarah Martinez has been a Department of Justice attorney for 12 years. Clean record, stellar reviews, dedicated public servant. 3 weeks ago, she stood before Judge Caldwell, representing the government in the Sanctuary City funding case. The transcript shows what happened when two legal authorities collided. Judge Caldwell asked the simple question that started this constitutional crisis. Miss Martinez, has your department released the funds as ordered by this court 72 hours ago? Martinez replied, Your Honor, we are working with our superiors to determine the appropriate compliance pathway. Judge Caldwell's response was immediate. That is not an answer to my question. Have the funds been released? Yes or no? The silence lasted 18 seconds. Court reporters time these moments. 18 seconds of a federal attorney unable to answer a direct question from a federal judge. Finally, Martinez answered, No, Your Honor, the funds have not been released. What followed reveals the impossible position these lawyers face. Judge Caldwell, Miss Martinez, are you refusing to comply with this court's order? Martinez, no, Your Honor, I am not personally refusing compliance. Judge Caldwell, then who is refusing? Martinez, I am not authorized to speak for department policy, Your Honor. Think about that exchange. A government lawyer cannot tell a federal judge who in the government is defying the court's order. She knows the answer. The judge knows she knows. Everyone in that courtroom knows. But she cannot say it because doing so would end her career and potentially expose her to retaliation from her own department. The next part of the transcript is even more revealing. Judge Caldwell, Miss Martinez, as an officer of this court, you have a professional obligation to ensure compliance with judicial orders. How do you reconcile that obligation with your current position? Martinez, Your Honor, I am trying to navigate competing professional obligations in an unprecedented situation. Translation: a career public servant is being forced to choose between following a federal judge or following her executive branch superiors. There is no right answer. Either choice destroys her career and potentially exposes her to legal jeopardy. And Sarah Martinez is not alone. In the past month, 17 Department of Justice attorneys have withdrawn from cases rather than face similar impossible choices. Attorney David Kim pulled out of the environmental regulation case in New York. His withdrawal letter, filed with the court, stated, Irreconcilable differences between court requirements and department directives make continued representation impossible. Attorney Rebecca Foster withdrew from the immigration detention case in Los Angeles. Her letter was more direct. I cannot in good conscience continue to represent positions that require defiance of direct judicial orders. Translation: career attorneys are abandoning cases rather than participate in systematic contempt of court. But here's what the math tells us about the scope of this crisis. In fiscal year 2023, Department of Justice attorneys withdrew from an average of 12 federal cases per month. In fiscal year 2024, that number jumped to 28 per month. In the first quarter of fiscal year 2025, we're seeing 43 withdrawals per month. That represents a 358% increase in attorney withdrawals from federal cases. Those numbers represent more than statistics. Each withdrawal is a career attorney choosing professional suicide over participating in judicial defiance. These are people with mortgages, families, law school loans. They're walking away from stable federal employment because they cannot reconcile their professional obligations with their departmental orders. District Judge Martinez in Los Angeles captured the human cost perfectly during a recent hearing. I am watching career public servants destroy their professional lives rather than participate in systematic contempt of this court's authority. This should outrage every American who believes in the rule of law. But here's the irony that should make everyone angry. These attorneys took an oath when they joined the Department of Justice. The oath requires them to support and defend the Constitution of the United States. It requires them to bear true faith and allegiance to the Constitution. Now they're being asked to violate that oath by ignoring federal court orders that are themselves constitutional exercises of judicial power. The law of unintended consequences is not theoretical. It is playing out in real time in courtrooms across America. Policies designed to assert executive authority are instead destroying the careers of dedicated public servants and creating a constitutional crisis that threatens the foundation of American legal system. Attorney Sarah Martinez faces a contempt hearing next Tuesday. If Judge Caldwell finds her in contempt, she could face fines and jail time for following orders from her own department. If she defies her department and complies with the court, she faces termination and potential retaliation from the executive branch. That is not a choice any attorney should have to make in a functioning democracy. That is the choice government lawyers are making every day as this constitutional crisis escalates. But wait, there's something they're not telling you about who enforces contempt orders when the executive branch controls the enforcement mechanism. Let me tell you about Maria Rodriguez, single mother of 2 in Phoenix, Arizona. Her husband was detained by immigration authorities 8 months ago under circumstances that violate federal court orders requiring release within 30 days for non-violent cases. Maria has been waiting for justice while lawyers argue about compliance procedures. Her 6-year-old daughter Sophia asks every night when Daddy is coming home. Maria told local reporters, "I tell her soon, but I don't know if that's true anymore." The judge said he should be released, but nobody seems to care what the judge says. Sophia's question represents the human cost of constitutional crisis. When courts lose the power to enforce their orders, real families suffer real consequences. Maria Rodriguez is not a political talking point. She is not a statistic. She is a mother watching the legal system fail her family in real time. And Maria is not alone. In the last 3 months, over 4,000 families have been affected by delayed compliance with federal court orders across immigration, federal contracting, and emergency relief cases. These are not abstract legal principles. These are people whose lives hang in the balance while government lawyers and federal judges engage in constitutional warfare. Court clerk Jennifer Walsh has seen the human impact firsthand. She processes the paperwork, schedules the hearings, watches families wait in courthouse hallways for decisions that may never be enforced. She told legal reporters, "I have been working federal courts for 18 years. I have never seen this level of uncertainty about whether court orders mean anything. Families come to court expecting justice. I don't know what to tell them anymore." Jennifer sees something most people miss. The courthouse staff who make the system work are watching it break down in real time. Clerks, bailiffs, court reporters, security officers. They're witnessing the erosion of institutional authority that has defined American justice for centuries. Let that sink in. The people who know the system best are watching it fail. But the crisis extends far beyond immigration cases. Federal contractor James Patterson from Denver represents another human face of enforcement failure. His construction company won a competitive bid for highway infrastructure work 9 months ago. Total contract value $2.4 million. Federal court orders required payment within 90 days of project completion. James completed the work on time. The court ordered payment. The money never came. James told the Denver Business Journal, "I had to lay off 12 employees. I had to take out a second mortgage on my house. The court said the government has to pay us. The government says they're reviewing compliance procedures. My workers don't care about compliance procedures. They care about feeding their families." Translation: when court orders become suggestions rather than commands, ordinary Americans pay the price. James Patterson built roads for his country. His country refuses to pay him despite direct judicial orders requiring payment. That is not a functioning democracy. That is a system in collapse. The pattern reveals itself in the numbers. Federal Emergency Management Agency reports show 847 delayed disaster relief payments, despite court orders requiring immediate distribution. Small Business Administration data reveals 1,203 delayed loan approvals despite judicial injunctions requiring processing. Housing and urban development statistics show 2,156 delayed housing assistance payments despite court mandates. Each delayed payment represents a family waiting for help their government promised and a court ordered. Lisa Chen from Seattle runs a small bakery destroyed by flooding last year. Federal disaster relief was supposed to provide rebuilding assistance within 60 days. A federal court ordered immediate processing when that deadline passed. 7 months later, Lisa is still waiting. She told the Seattle Times, "I trusted the system. I believed when the judge said they had to help us, that meant something. I was wrong." Lisa Chen represents the collapse of institutional trust. When courts cannot enforce their orders, citizens lose faith in the entire system. Not just the executive branch, not just the judicial branch. The entire concept of legal authority becomes meaningless. Federal Judge Patricia Martinez captured this erosion perfectly during a recent hearing. "I am watching the rule of law become a suggestion rather than a requirement. I am watching families suffer while government lawyers claim they need more time to understand orders written in plain English. This should terrify every American citizen regardless of their political affiliation." But here's what makes this crisis particularly dangerous. These are not political cases. These are not partisan legal battles. These are basic government functions that courts ordered to proceed normally. When even routine judicial orders become subject to compliance reviews and departmental interpretations, no court order is safe from executive defiance. Constitutional law professor David Chen from Georgetown University told The Washington Post, "We are witnessing the systematic erosion of judicial authority across the entire spectrum of federal law. This is not about immigration policy or environmental regulation. This is about whether federal court orders carry any legal weight whatsoever." Translation: the constitutional principle of separation of powers is breaking down in real time. Think about what that means for ordinary Americans. When you cannot trust that court orders will be enforced, you cannot trust the legal system to protect your rights. When the legal system loses credibility, democracy itself becomes vulnerable to collapse. The death threats against federal judges have increased 400% in the past year. Federal Judge Susan Torres from Tampa received 17 threats after issuing contempt warnings to government lawyers. The threats came from both sides, people angry that she's challenging the executive branch, and people angry that her orders aren't being enforced. She told Judicial Security, "I am being threatened for doing my job and threatened for not being able to do my job effectively." That is the definition of institutional breakdown. And here's the accountability question that should keep everyone awake at night. If federal judges cannot enforce their orders, who protects your constitutional rights when the government violates them? Here's what nobody is saying out loud about the enforcement crisis. When Judge Caldwell threatens to hold government lawyers in contempt, she's assuming the US Marshals Service will arrest them. But the Marshals don't work for Judge Caldwell. They work for the Department of Justice, the same Department of Justice whose lawyers she wants arrested. Think about that structural impossibility. Title 28 of the U.S. Code gives marshals their authority to provide security and to obey, execute, and enforce all orders of United States District Courts. But Title 5 places them under executive branch control through the Attorney General. When those two authorities conflict, which one wins? Constitutional law expert Professor Sarah Williams from Harvard Law School told Congress last month, "We have discovered a fatal flaw in our separation of powers. The judicial branch depends on executive branch employees to enforce orders against the executive branch. This is like asking someone to arrest their own boss." Translation: the system assumes cooperation that no longer exists. The numbers reveal the scope of this structural crisis. In the past fiscal year, federal courts issued 847 contempt citations against government officials or attorneys. Of those, 234 required physical enforcement action by marshals. In 31 cases, marshal supervisors reported conflicts between court orders and executive branch directives. That represents a 3,400% increase from the previous decade's average of less than one conflicted case per year. This isn't theoretical anymore. It's mathematical. When enforcement mechanisms fail, judicial authority becomes meaningless, and Congress knows it. Representative Alexandria Martinez from the House Judiciary Committee introduced the MARSHALS Act 3 months ago. The proposed legislation would transfer the U.S. Marshals Service from executive branch control to judicial branch oversight. Martinez told the House floor, "We cannot have a democracy where the executive branch controls the enforcement of judicial orders against the executive branch. This creates an impossible conflict of interest that undermines the entire constitutional framework." But the bill faces fierce opposition from executive branch officials who understand that enforcement control equals real power. Here's where it gets worse. Federal courts are already exploring alternative enforcement mechanisms. District Judge Robert Chen in New York issued an unprecedented order last month appointing private attorneys to pursue contempt enforcement when U.S. attorneys declined to prosecute. Judge Chen wrote, "This court cannot allow its orders to become mere suggestions because the traditional enforcement mechanism has been compromised. International legal experts are watching this crisis with growing alarm." Dr. Hans Muller from the International Court of Justice told Reuters, "American democratic institutions have served as a model for judicial independence worldwide. When that model breaks down, it threatens rule of law globally. Other democracies are questioning whether the American system can survive this institutional conflict."